the lights. Could you turn on the lights just in the front? So today we're going to do what is hearsay. And I actually, I want to try these clickers out. I think I have a way to do it now. And so this should work. And this way you can help the panel. So what I'll do is I'll get the panel together, and then I'll administer this quiz that I wrote up this morning, and the panel will struggle with the issues, and then we'll all vote and see if you're getting it. Okay? So this will be fun. So everybody got their clickers? Got their clickers out? All right. Okay. Anyway. So what we're going to do today is the first of 2 days on what is hearsay, because it takes 2 days just to figure out what it is. Most of today is actually pretty straightforward and simple. It's just about, what are the basic definitions, what are the basic concepts. The most difficult class will be next Monday when we talk about the hearsay the non-hearsay arguments. I was starting to say hearsay exceptions, and I've got to keep those distinct. There are these very subtle and difficult to understand arguments about how some things are not hearsay. But you don't have to worry too much about that, because today you just want to know what is hearsay. And some of the things today will surprise you. So some of the things seem like they shouldn't be hearsay, but the point is going to be stick to the definition. If you read the definition carefully, you'll see it is hearsay. And also stick to the concept of why hearsay is bad, as we'll explain. And if you understand why hearsay is bad, then you'll understand why some of these things that you might not normally think are hearsay are not. I think what is most surprising today is there are certain things that are categorically not hearsay, but maybe should be. But again, you're going to stick to the definition in order to understand the rule. You had a little bit more reading than usual, and I got to tell you, Mueller and Kirkpatrick do a pretty good job of explaining the concept of hearsay, but I actually think they mess up a bit, and just about anybody you read in this topic is going to mess up a bit. So it's just not going to be simple and straightforward. And of course, you all recognize Senator Clinton, since she's been in the news a lot. I don't know if any of you recognize this man standing next to her. That's Bill Clinton. And we'll be talking actually more about Mr. Bill Clinton than we will about Ms. Hillary Clinton. But that comes later. The first thing we're going to talk about is personal knowledge. Now, you say, wait a minute, we're talking about hearsay. But personal knowledge is really the basis for the hearsay objection. Personal knowledge is the rule that you have to know, have directly perceived the information that you're testifying about. Okay? And the language of personal knowledge will remind you of language we just saw with respect to authentication and which we've recently seen with respect to conditional relevance. So it talks about evidence sufficient to support a finding. So you get that hammered into your head by the end of today. We'll talk about how witnesses can be wrong, because how witnesses can be wrong will help us to explain the potential problems with hearsay. So we'll naturally then move to why hearsay is bad, right? Why is hearsay less likely to be true, and why does hearsay not abide by the procedural conventions that the law has adopted to find truth? And by the procedural conventions, of course, I mean the trial process. So we'll talk about that in two ways. Hearsay is bad because it's unreliable. Hearsay is bad because it violates our rules of procedure, our rules of getting at the truth in a trial. We'll talk about the basic definition of hearsay, which is found in 801. We'll talk about witnesses versus declarants. Okay? A declarant, as you'll find out, is anybody who says anything, or it could even be anybody who writes something. Those are all declarants. And there's a difference between in-court declarants and out-of-court declarants that will help us to define hearsay. But to cut to the chase, the tricky things are going to be that quoting yourself is often hearsay. Quoting yourself is often hearsay. Quoting testimony is often hearsay. All right? And once you just learn this rule, you'll never forget it. We'll then talk about, a lot to do, assertions versus non-assertive conduct. Okay? Hearsay is in part defined by the fact that it has an assertion. And non-assertive conduct is going to be non-hearsay. However, that doesn't mean that whether something is spoken or not spoken, that determines whether it is hearsay. Non-verbal assertions are going to be hearsay. Simple example will be, are you the murderer? That's non-verbal, but I'm saying yes. silently. That is hearsay. Okay? We'll see how involuntary actions are not hearsay, even if those involuntary actions can be read by others as suggesting something. So you might say to me, "Are you the murderer?" And I go, "Oh, what?" That's involuntary. You'd say, "Hey, he confessed," but not in a voluntary way. He involuntarily demonstrated that not only does he have a bad chest cold, but he's the murderer. That would not be hearsay. See, it's we're collaborators in crime. Voluntary actions. Voluntary actions may be hearsay. The fact whether it's verbal or nonverbal isn't going to matter. It's going to depend on what you're trying to do through those voluntary actions. And finally, silence. Will we get to silence? I take that as a yes. Okay. Hidden hearsay. Hidden hearsay is interesting. Hidden hearsay is when you have beliefs and actions based on hearsay. And so you'll have a hearsay objection that you can make, but you may have to make a personal knowledge objection first to uncover the fact that the source of the person's knowledge is hearsay, right? That the source of their knowledge is what someone told them or what they read somewhere. And then finally, we'll talk about machines and animals. Two of my favorite things. And we'll talk about how, surprisingly enough, machines and animals are usually not hearsay declarants. At least not until the premise of 2001 comes true, right? You know what the premise of 2001 was. You're thinking, 2001? That was 5 years ago, man. What are you talking about? I mean, the movie 2001, right? The premise is that computers at some point could form self-consciousness, and once they formed self-consciousness, they could be evil, and they could try to take over the world. But luckily, we're still not at that point yet. Although sometimes I think Bill Gates is working hard to reach that point. Okay, Rule 602, lack of personal knowledge. Just read the rule and then I'll tell you what to write. A witness may not testify to a matter unless evidence is introduced sufficient to support a finding, hey, you've heard that before, that the witness has personal knowledge of the matter. Write this, witness must have personal knowledge. You've already got that in your notes. You're not even going to click. Not even make me feel good? Okay, it's already in your notes. In other words, that is, i.e., from the advisory committee notes, and they're the people who wrote the rules, and they tell us what they mean. Witnesses must have perceived what they testify to, right? And you've heard that, just tell me what you saw and heard, right? That's the personal knowledge requirement. Now, personal knowledge necessarily means that you cannot speculate, right? You cannot speculate. And it also means, as you'll see, is you cannot rely on what others have told you or what you have read. And that will form the basis of the hearsay objection. You also want to make sure that your notes have this language. There must be evidence, quote, sufficient to support a finding, unquote, of personal knowledge. And as you know, what does that mean? Means that personal knowledge is a conditional relevance issue. And how is it a conditional relevance issue? Well, think about that. Bill killed Jim, or I guess our example today is going to be Al killed Bob. So to be consistent, I'll say that. Al killed Bob. And you say, that's good evidence. And someone else says, wait a minute. Him just saying that isn't good evidence. He has to know it, right? So you say, whether him saying that Al killed Bob is good evidence depends. That's conditional relevance. It depends on whether he saw Al killed Bob, whether he has personal knowledge of it, right? So it's a conditional relevance issue. And therefore, the judge doesn't have to be convinced that the person has personal knowledge. There only must be evidence sufficient to support a finding, which means there must be some foundation for that belief. Well, it turns out that the foundation can be very simple. All right? Evidence to prove personal knowledge may but need not consist of the witness's own testimony. And you can write this down. The witness can provide the foundation for her personal knowledge. How do you know? I saw it. That's sufficient. That's sufficient. And if you think about it, it has to be sufficient, because if it weren't, we'd have this endless, what would you call, this reductio ad absurdum situation where the person would have to find somebody else who could testify, but then how do they know it? They'd have to find somebody else. So I know it because I saw it. Okay. Personal knowledge, of course, doesn't guarantee that what the person said is true. Witnesses can be wrong. And you want to understand the different ways in which witnesses can be wrong, because this will help you to understand the dangers of hearsay. Okay? And how can witnesses be wrong? Well, imagine I say Al killed Bob. Okay? Think of all of the various reasons why I might be inaccurate, even though I say I saw Al kill Bob. The first problem is, well, maybe my perceptions are poor, right? It was dark. I don't really know what Al looks like. My perceptions might be biased by my personal views. I think Al's a killer, and so I assumed it was Al. That's the first problem. The second problem, maybe my perceptions were clear, but at the time of perceiving, I didn't think it was Al at all that killed Bob. But over the course of months and months and months of reading about it in the newspapers and hearing my friends talk about Al being a bad person, I ultimately decide, yeah, now I remember, Al killed Bob. So my memory might be inaccurate, right? Okay. Now, these two things are problems where I sincerely believe that Al killed Bob, but I'm wrong. But there are two other problems that occur in cases where I don't truly believe that Al killed Bob. Well, how can that happen? Well, maybe when I say Al killed Bob, I mean Al, is just a jokester, and Al killed Bob. He killed him, man. He told him a bunch of jokes, and Bob just couldn't stop laughing. And when I say Al killed Bob, it sounds like I'm saying he killed him, and it's a problem of narration. It's a problem of ambiguity of my speech. So it's not me that's misinterpreting. It's you that's misinterpreting, right? And then the last thing, and this turns out to be the most important thing that the rules of evidence care more about than any other thing. And actually, if you learn that now, if you say, okay, sincerity is unusually important, this last thing, sincerity, is unusually important, you'll understand a lot of rules a lot better. Sincerity drives our concerns about witnesses. And what is sincerity? Of course, it's whether you're lying or not. So I can say Al killed Bob, I cannot truly believe it, but I'm trying to mislead you. And that is another problem with witnesses. Okay, so we have the trial process, and the trial process tests witnesses' accuracy. And how does it do that? The first way it does that is witnesses have to take an oath. Now, you probably think this is a silly ritual. And you're partly right and you're partly wrong. Have any of you ever had to take an oath? Like, have you ever been sworn onto a jury? I don't know if this is true for you. I mean, I'm this, cynical evidence professor, but I was actually put on a jury, even though I was an evidence professor. I couldn't believe it. I actually wasn't able to listen to most of the trial because someone would say something and someone would object, and I'd be going, oh, wow, it's an interesting objection. I wonder if that really is hearsay. And then when I'd look up again, they would be like done with the testimony and moving on to the next witness. So I wasn't that great a juror. But the oath was amazing because, you swear to tell the truth as a juror, and I felt nervous. And then when they started asking questions like, have you ever been the victim of a crime? I said no, but then I started thinking, oh my God, there was that time that, Billy Jameson stole my bicycle when I was in second grade. And it wasn't just me. Other jurors were also like raising their hands and going, oh my God, I forgot, actually, I was a victim of a crime. A guy, one time he ran into me and then he ran off, and I think that's hit and run. They're like, but you didn't commit the crime. Oh, okay. But you see, the idea is the oath had such a strong effect on us, and we didn't realize it did. Now, in the old days, this was universally understood to have a huge effect on people. So up until about 1770, 1780, this was the main guarantee of truth, because people sincerely believed that if you put your hand on the Bible and swore to tell the truth, and you didn't, you were condemned to hell everlasting. Right? Eternal flames. Or as little kids would say, you would go to the bad man. And no one wants to go to the bad man. Well, about 1780, the lawyers started moving in. And the lawyers created a totally different way of testing truth. The oath kind of fell by the wayside. Now we just do it as a, yeah, put your hand on the Bible. Okay, yeah, I'll tell the truth. It doesn't really matter, but what really matters is we test people's accuracy through cross-examination. And Wigmore, and you know Wigmore is the great evidence scholar that I think I mentioned on the first day of class, the guy who wrote a code that no one adopted. Wigmore said, cross-examination is the greatest legal engine ever invented for the discovery of truth. He really meant it. Now people say it and they kind of snigger. But the idea is that that is going to uncover inaccuracies and biases in witnesses' testimony. And the third way that the trial process tests witness accuracy is through demeanor. Okay, demeanor. What's demeanor? Demeanor is that the witness has to confront the courtroom. Now, you know about the confrontation clause. That's the idea that you have to confront the accused. You have to stare them eye to eye. And of course, that's going to uncover the liar. They have to also face the jury. The jury can watch the witness, and the jury can assess the accuracy of the witness by watching the witness. Now again, this is, just like with the oath, this is folklore, right? It turns out that empirically, jurors, mock jurors, are pretty much at chance when it comes to telling liars. It turns out that even police officers who, think they're really good at lying detection are terrible, partly because a police officer will tell you, you can tell a guy's lying if he opens his mouth when he talks, right? That's what they'll tell you. And they know that's a joke, right? You didn't know that was a joke, and I hope you didn't write it down. But anyway, what they're saying is they think everyone's a liar, so they just overcall it. The problem that jurors have is jurors think that things like avoiding eye contact is a sign of lying. And in fact, there's these studies where they find across the world, people think that means you're lying, when in fact it doesn't mean you're lying. If you're a good liar, right, and I'm sure you've practiced this, when you need to lie to somebody, you say, I was out with my friends, right? You look them right in the eye and tell them the lie, and any kind of evasiveness is going to send you to hell. I don't know if you gathered that, but I was imagining a conversation with my wife. Okay, the problem with hearsay. So now we understand the dangers of witnesses, right, how they can be inaccurate, and we understand how the trial solves all that through oath, cross-examination, and demeanor. Well, why is hearsay bad? We're now ready to understand why hearsay is bad. Here's a classic piece of hearsay. This is, Wendy testifies, Deborah said, Al killed Bob. Okay. And this is important. You'll see this next time. Evidence is offered to prove that Al killed Bob. All right? And you want to ask yourself, why would Al be upset by this testimony? Well, obviously he's upset because they're putting the finger on him. But why would Al say, as a procedural matter, how could Al complain? How could Al say, this isn't fair, this isn't right? Right? Well, Al would say, this isn't right. And the lawyer says, we got Wendy up on the stand here. She's under oath. She's subject to cross-examination, right? The jury can look at her demeanor and see if she's being honest or not. What's your problem? And Al will say, my problem isn't that Wendy is testifying, it's that the person who's really testifying here, right, the person whose statement is really doing me in, is not Wendy, it's Deborah. And Deborah is not under oath, right? Deborah is not subject to cross-examination. And Deborah, we have no idea what her demeanor is, or was, or would be, if you brought her in, okay? So Wendy, I don't care. Wendy's just quoting. She's just a vessel for communicating the real accuser here. And the real accuser is Deborah. Deborah might have misperceived, right? Deborah might have misremembered. Deborah might be misinterpreted. Deborah might be insincere. And does Wendy know any of that? Well, Wendy might have some suspicions, so maybe Wendy can help to describe Deborah's demeanor, or maybe she was misperceived. But that's all secondhand, right? The problem with hearsay is that the declarant, the person who uttered the hearsay words, has all those witness infirmities, and the declarant is not subject to any of the trial process that allows us to uncover those infirmities. That's the problem with hearsay. And you do want to understand hearsay both as a objection, right? Because that's something that lawyers just, I mean, it's almost like a knee-jerk response. You hear something that sounds wrong and you say, objection, hearsay. But you also want to understand why hearsay is a bad thing. So like, for example, during the trial, during the O.J. trial, one of the good things that Cochran did, among many other things, is when he would make a hearsay objection, he would often not say objection hearsay, which sounds like a technical thing to jurors. He'd say, in this case, he'd say, objection, we don't have Deborah here to testify, right? Because that's the real conceptual problem with hearsay. And then the jury would hear that and they go, yeah, why don't we have Deborah here? Okay. So that's the problem with hearsay. Now let's look at the definition in 801. And here's what it says. It says, hearsay is a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. And I'm going to simplify this a little bit so that you can memorize it. Remember the first day? Do you still remember that? We recited it. So hopefully it's you know about savings, right? Savings is, even if you don't remember, you'll remember it. It'll be easier to memorize now that you've memorized it once. Hearsay is an out-of-court assertion offered to prove the truth of the matter asserted. Now, I've slightly rewritten it, so it's slightly inaccurate, but it will do you in most cases, okay? Out-of-court assertion offered to prove the truth of the matter asserted. Now, this offered to prove the truth of the matter asserted sounds really weird, kind of reflexive, and it is weird. And we won't deal with this issue very much until next time, when we talk about how some statements may not be hearsay, not because they're not out-of-court assertions, they are, but because they're offered to prove something other than what they assert. Right? And that will be kind of mind-boggling. But for now, you really want to focus on the out-of-court assertion. And remember our Al killed Bob? This is an easy example. Why is it easy? Well, here's our definition of hearsay, right? Here's our example of hearsay. And here's what we're asking. What's the out-of-court assertion? Al killed Bob. What is it offered to prove? Al killed Bob. So for now, for today, we've got an easy time with that offered to prove the truth of the matter asserted. Because we're assuming that what Deborah said, what Deborah asserted, is the same as what we're trying to prove by getting Deborah's statement into evidence. Okay? So that part is easy. Let me say a little bit more about, I've been using the term declarant, and we'll see the term declarant again and again. So let me draw a distinction for you between in-court declarants and out-of-court declarants. Anyone who says anything is a declarant. Okay? So here we've got Wendy testifies. Deborah said Al killed Bob. Wendy is a declarant, but she's an in-court declarant. And another word for an in-court declarant is a witness. She is under oath. Her demeanor is being tested. And she's cross-examinable. And what's Deborah? What is Deborah? She's an out-of-court declarant. Okay? And it's the out-of-court declarants who are going to be the hearsay declarants. All right. Now, why do I do this in-court, out-of-court? Why don't I just say declarant? Because the definition of hearsay gets confusing unless you realize that anybody who says anything is a declarant, and that it's the out-of-court declarants that we're concerned about. Because the rule says, hearsay is a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Okay? Now that's a complicated way of saying it. Why don't they just say out-of-court declarant? We'll see that it matters for quoting yourself later on. But for now, look at that language. Other than one made by the declarant while testifying at the trial or hearing. Why do they say it that way? Well, they don't want everything anybody says to be definable as hearsay. So remember, Deborah? Well, lo and behold, Deborah shows up. Now, no hearsay, right? Deborah testifies, Al killed Bob. No hearsay. Is Al killed Bob a statement offered to prove the truth of the matter asserted? Is Deborah testifying that Al killed Bob in order to prove that Al killed Bob? Surely yes. Why isn't this hearsay? Right? Why isn't this hearsay? because this statement is made by the declarant while testifying. Okay, voila. We've now avoided the problem that everything anybody says is hearsay. Hearsay is only when there's a statement that is not being made by the declarant while testifying at the trial or the hearing. If Deborah testifies to Al killed Bob, it is not hearsay. But if someone quotes her testifying Al killed Bob, it is hearsay. All right. Now, this complicated definition allows us to recognize a very simple truth that our out-of-court declarant definition, the one that you memorize, would not. So I want to emphasize this little point. Repeating one's out-of-court statements. If you repeat, quote what you've said before, is that hearsay? And let's look at an example and think about it. Wendy testifies, I told the police Al killed Bob, offered to prove that Al killed Bob. All right. Let's ask the questions. Is Al killed Bob a statement offered to prove the truth of the matter asserted? Easy question, because it's always going to be yes today. The answer is always going to be yes. Yes, it's offered to prove that Al killed Bob. In fact, it says it in that very first sentence. Well, then the only other question, is that a statement made by the declarant while testifying? The blue. Is the blue a statement made by the declarant while testifying? No. She's not saying Al killed Bob. She's saying, I told the police Al killed Bob. It would be hearsay for Wendy to say, I told the police Al killed Bob. But if Wendy simply states Al killed Bob, it would not be hearsay. All right? Seems a little screwy, hopefully. If it doesn't seem screwy at all, you're probably not understanding. So it should seem a little screwy. Quoting yourself is hearsay. And why is it screwy? Well, think about the trial process, right? You could say, it doesn't make sense. You should be able to say, I told the police that Al killed Bob because I'm under oath, I'm subject to cross-examination, and my demeanor is being examined, right? So I should be able to quote myself all the time. And here's the way to think about it. If you're in a situation where someone says to you, did Al kill Bob? And you say, well, I told the police that. Are you swearing to God that Al killed Bob? No, you're hiding behind your former statement, right? You're hiding behind your statement. And what the rule says and what the rule means is that the statement should be subject to the trial process. Now, you can say to Wendy, okay, you told the police that. That's hearsay. Did Al kill Bob? Yes. Now, you can be cross-examined properly. So the idea is that quoting yourself is hearsay because you can't hide behind your prior statement, right? That would not allow the trial process to proceed properly. Okay. Well, another screwy thing is going to be repeating testimony. What if Wendy doesn't testify that I told the police that Al killed Bob, but she testifies that I previously testified, and you could say either at a prior hearing, like the prelim, or at a prior trial, let's say the jury hung, and now they're retrying Al. I previously testified Al killed Bob, offered to prove that Al killed Bob. We ripped through this question because it is offered to prove the truth of the matter asserted. I just want you to get used to ask yourself that question. And then ask this question. Is this, in blue, Al killed Bob, a statement made by the declarant while testifying at the trial or hearing? And the answer is no, she's not quoting herself at this trial. She's not testifying directly that Al killed Bob. She's hiding behind her prior statement, even though that prior statement was testimony. Even though that prior statement was under oath, subject to cross-examination, and subject to demeanor analysis, it doesn't fit the definition, or I should say it does fit the definition of hearsay, because, right, because it's not a statement made by the declarant while testifying at the trial or hearing. So quoting your prior testimony, or for that matter, quoting anyone's testimony, is hearsay. Okay? And again, hopefully you're saying, well, wait a minute, that doesn't make sense, because you're subject to the oath, cross-examination, and demeanor analysis, right? If it's prior testimony, it was subject to these things. And the way you want to think about it is, the person and their statement should be examined by this trial, this tribunal, this jury. That's the rights you have as a defendant, is bring them in and have them say it before this jury, because this is the jury that's deciding my fate. And once you get past the screwy logic and simply remember the rule, it's easy. Is quoting yourself hearsay? Yes. Is quoting testimony hearsay? Yes. Now, is it ever okay to quote yourself? Is it ever okay to quote testimony? Yes. There are hearsay exceptions. There's a hearsay exception called the former testimony exception. There's a hearsay exception called identification exception, which both allow you to quote yourself and to quote testimony. But those are exceptions to the hearsay rule with their own rules. So before you get to the exceptions, you need to know the rule. And the rule is quoting yourself or quoting testimony is hearsay if offered to prove the truth of the matter asserted. All right? So that's pretty straightforward, I hope. Now let's talk about that issue of offered to prove the truth of the matter asserted. Notice that you have two things going on here, right? You have something that's offered to prove, so there's something you're offering to prove. It's what you're trying to prove. And there's something being asserted. And those two have to be the same for hearsay to exist. Okay, so I'm going to make this really clear now, and this will be even more important on Monday. Who is doing the asserting? So if Wendy testifies that Deborah said, Al killed Bob, who's asserting? Who's asserting? The declarant, and specifically the out-of-court declarant, Deborah. Okay, Deborah's the declarant. And she's the one asserting. And what she means when we say assert, as you'll see, she means she's intending to communicate, she's intending to express the fact that Al killed Bob. But who's offering? Right? Offered to prove, who is offering the statement? Well, you might say it's Wendy, but that's wrong. It's the party who's presenting the testimony. It's the party seeking to admit the statement. And remember when I said the very first question you ask about any piece of evidence is, what are you trying to prove? What are you offering to prove? This question will be important in hearsay analysis. And as you know, you, the party, are trying to prove something. So, as we'll see even more clearly on Monday, the declarant may assert one thing, but the statement may be offered to prove something else, and that will be non-hearsay. Okay, so the declarant may assert one thing, but the statement may be offered to prove something else. All right, just get that into your head, that non-hearsay can be a disconnect between what's offered to prove and what the declarant is asserting, and then that will come out again Monday when you really have to apply it. I've been saying asserted, offered to prove the truth of the matter asserted. What is an assertion? And here you have to type something, even if you got your notes, because I added or expression. Yeah, I hear that. Wait a minute. I think you made a typo. That was one too many letters. Okay. An assertion is an intended communication or expression. You're trying to say something. That's an assertion. Notice it has to be intended. Okay? It has to be voluntary. Bless you. And the reason why I say communication or expression is the treatise goes on and on and on about how maybe we are communicating when we write things in a diary. Well, I think we're communicating to ourselves. So I didn't have any problems with using communication. But other people say, no, I'm not communicating anything. So I use the word expression to make clear that it doesn't have to be the idea that you're trying to tell somebody else something. It's just that you're trying to express something. It includes oral or written assertions, right? You can say it, you can write it. Either way, it's an assertion. So Wendy testifies, Deborah wrote me a letter that Al killed Bob. Deborah is the out-of-court declarant because she's the author of the letter. Wendy doesn't testify at all. We just bring in a letter, signed Deborah. Dear prosecutor, Al killed Bob, love Deborah. Deborah is the out-of-court declarant, okay? Is there anything else? Can it be anything else? Oh, yes. It can include the nonverbal conduct of a person if it is intended by the person as an assertion. It sounds complicated, but it's really easy. Nod in your head. In our culture, that means yes. Although, you know, in some cultures, nodding your head means no. Gets you into a lot of trouble, right? Are you bringing in any illegal substances? That means yes. That means no, right? Shrugging your shoulders. In our culture, that means, I don't know. Does anyone know about other cultures? Whether a shrugging is a universal sign of I don't know? And pointing is a means of communicating, right? Who killed Bob? That fellow without a name tag gets picked on. So what would be examples? Oh, well, I've already told you these examples. Wendy testifies, I asked Deborah if Al killed Bob, and she nodded. Wendy testifies, I asked Deborah who killed Bob, and she pointed it out. How about this? I asked Deborah if Al killed Bob, and she went into violent convulsions. Violent convulsions, usually involuntary. No, not hearsay. Admissible. Now that seems wrong. But we'll talk about that a little bit more. For now, recognize that if something is not intended as an assertion, it's not hearsay. Okay? So involuntary actions are not hearsay. And why is this screwy? Well, I shouldn't have put it in your notes. I should have hidden it so you had to think a little bit. But either read the next sentence or think about this and say to yourself, why is this screwy? Well, imagine how convinced you would be, right? If I say to you, I asked the dean, can I have another $10,000 to spend on my electronic toys? And he nods his head, you'd be pretty convinced that the answer was yes. And if I say, I asked the dean if I could have $10,000 for my toys, and he started, jerking around, you'd say, well, that's clearly less convincing evidence that he said yes, even if you might interpret it as some sort of affirmation. Very strange meetings I've had with the dean, as you can tell. It's screwy because it is so easy to imagine you being wrong about your interpretation of this involuntary action, right? Let's say that Deborah does believe that Al killed Bob, and that was the source of her violent convulsions, but she might be wrong. Remember? She might have misperceived, or she might have misremembered. And the fact that its actions are voluntary or involuntary, it doesn't affect whether she's accurate or not in her beliefs. Another thing is, you could misinterpret her actions, her convulsions, right? And this is the problem with lie detector tests. The problem with lie detector tests is they ask you, did you kill Bob? And you say no, and your lie detector, your skin conductance goes way up. You start sweating, and they say, you're lying. Well, no, that's a misinterpretation of your involuntary response. You're involuntarily responding because they're accusing you of a crime, not because you're guilty. So we may be misinterpreting. So you have a problem with perception, memory, and narration. But remember what I said when I said sincerity? I said sincerity is the most important thing. And that's all that matters to the advisory committee and to the definition of hearsay. Because the risk of insincerity is non-existent. If she truly is involuntarily reacting to your statement, she cannot be insincere. Now stop and think about that. How is it that you can't be lying if your actions are involuntary? How is it that you can't be lying if your actions are involuntary? Well, if you involuntarily tell something that isn't true, is that a lie? You involuntarily say something that isn't true. Well, when would you involuntarily say something that isn't true? If you make a mistake, right? If you make a mistake. Is that a lie? No. That's something you learn when you're 5. You distinguish between mistakes and lies. And so does the rule. So the rule says, if you're simply mistaken and the action is involuntary, we don't worry about it. It's not hearsay. It doesn't count as hearsay. This doesn't mean you can't object to it. You can object to it as misleading the jury, as prejudicial. You already have a few tricks in your pocket, but you can't object to it as hearsay. Okay, what about voluntary actions? Does this mean that if involuntary actions are not hearsay, does this mean that all voluntary actions are hearsay? So I'd say, where is Professor Lyon's office? Well, I saw him walk into room 472. So it's room 472. So witness testifies, Professor Lyon walked into room 472 to prove that his office is 472. Is that hearsay? You'd say, well, gee, involuntary action. It's voluntary. He goes into the room. He might have misperceived it. He might not have been. He might not have been saying, "This is my office." He might have been going into someone else's office to visit. So there's a problem of narration. There's all these problems with that, right? But notice that I'm not intending to communicate. I'm not trying to communicate when I walk into my office, or when I walk into room 472, which is my office. So voluntary actions aren't necessarily hearsay. It depends on whether the person is intentionally communicating or expressing something. That gets a little tricky. So voluntary actions are not always hearsay. And here's how you can test for this, is you ask yourself a couple questions. You say, well, is insincerity a problem? Do I worry that that person committing that voluntary action was lying, was intentionally trying to deceive someone? Right? So you could imagine situations where it would be a lie. So someone is following me, right? And I think they're going to kill me. So I walk into room 472 to try to throw them off the trail. I'm trying to get them to think that it's my office. That then becomes hearsay. Consider this. Imagine if the person would have behaved the same had no one been watching. Now again, it isn't an ironclad test, because remember, you can communicate to yourself. But it gives you a good idea of the distinctions that we draw in everyday life. If we would have behaved the same had nobody been watching, it is less likely to be an intent, an effort, a voluntary action, trying to communicate. And, of course, it follows then that it's less likely that you were trying to lie. Because lying is usually about lying to others. So let me give you a couple examples of intentional, voluntary actions that may or may not be hearsay. So imagine this situation. The ship captain examines the ship before embarking on it with his family, offered to prove that the ship is seaworthy. So here's the way it would work. The witness comes into court, and they say, well, how did you know that the ship was seaworthy? Well, I saw the ship captain. I saw him examine the ship, and then I saw him walk up the plank to the ship, not off the plank, to the ship with his family. Okay, is that hearsay? Well, if you think about the hearsay dangers, you could say, might be, because the ship captain might have misperceived, or he might have forgotten something that was wrong, or he might not have been we might not be able to read his actions as saying that the ship was seaworthy. He might have been heading out for a suicide cruise, right? So all of those things are dangers, but is it likely that he was intentionally trying to deceive? And if we don't think he was trying to deceive, trying to communicate, if we don't think that sincerity is a problem, it's considered non-assertive conduct, and it would be admissible. And once you get into court, you realize we talk about non-assertive conduct all the time. I'm going to give you an example in the next slide that makes clear. You would never think of it as hearsay. However, you can imagine situations where this would be hearsay. So imagine that instead of the ship captain, we have the chairman of the Federal Energy Commission, who, on a very highly publicized trip, goes out to the nuclear power plant, walks around it, right, and then nods, showing his spirit of approval that this nuclear power plant is safe, right? That could be hearsay because you have a risk of insincerity. Or another example, ripped from the headlines, after it's discovered, and this is incontrovertible proof because amazingly enough we have DNA evidence that a politician has had an illicit affair and later lied about it with an intern, that weekend he goes to church, comes out of church holding a Bible in one hand, holding his wife in the other. And this is offered in evidence to prove, no, you can't believe this DNA evidence. This is proof that he is not an adulterous man, right? Well, do you think that would be non-hearsay if offered to prove? Or do you think he was trying to communicate something? Ironically, he wasn't trying to communicate anything. Bill Clinton, every Sunday of every week since he had become president, walked out of church holding a Bible in one hand and Hillary in the other. It was only this Sunday that the press decided this was an interesting picture, right? It was only this Sunday they decided, gee, that looks a little funny, so we're going to print it. So he really wasn't trying to communicate anything, and it wouldn't be hearsay. But you can easily see examples where voluntary actions are hearsay if they're intended to communicate. And remember why? Because there's a danger of insincerity. There's a danger they're trying to fool us with their actions. And you want to be careful because there are all sorts of hearsay dangers with non-assertive conduct. And non-assertive conduct is simply not hearsay. So imagine this situation. The plaintiff testifies that the truck driver drove into the intersection, offered to prove that the light had turned green. Non-hearsay, right? Because the truck driver wasn't trying to tell anybody that the light had turned green. And compare this to the truck driver yelled, "The light is green. Green means go." That would be hearsay. Can you imagine situations in which you would trust the second statement more than the first statement? What if the truck driver is in the right lane and you're in a right turn on red jurisdiction? Can you really say that the truck driver pulling into the intersection is non-problematic as evidence that the light turned green? Or would you more trust the truck driver who actually says the light turned green? You can think of lots of situations where the non-assertive, non-hearsay is more reliable, but it doesn't matter because sincerity is the key to distinguishing between hearsay that is assertive conduct and non-hearsay which is not. Okay? Okay. Now let's connect the dots between the personal knowledge issue and the hearsay issue. Okay? Connect the dots between personal knowledge and hearsay. So imagine this situation. A witness expresses her belief based on hearsay. And here's how it might work, is the witness just comes in and asserts Al killed Bob. Is there a hearsay problem there? No, she's saying it happened. So how do you get at the hearsay problem? Well, remember that personal knowledge is a foundational requirement. And how do you establish the foundation? You say, well, how do you know? That's a personal knowledge objection. How do you know? Right? Do you really know? Did you perceive it? Did you see it? Do you remember it? And she'd say, well, Deborah told me. Then you make the hearsay objection. Okay? So what often happens in court is that people will assert their knowledge, you make a personal knowledge objection, then they tell you because I heard, and then you make the hearsay objection. Now a harder example, a harder situation, is where a witness describes an action that is based on hearsay. And that action leads you to believe that something is true. So Wendy might say, let's say Wendy's a detective. I talked to Deborah, and then I went and arrested Al for killing Bob. I talked to Deborah, personal knowledge. I went and arrested Al for killing Bob, personal knowledge. No hearsay. There's no hearsay. Unobjectionable. And people have actually tried to get around the hearsay rule by doing this. They say, well, I talked to the informant, and he said, objection, hearsay. Okay, I won't tell you what he said, but later that day I arrested the defendant. And the jury's all going, yeah, we understand because the informant told you that he did it. That would be indirect hearsay, and that would be objectionable. Okay? And what you do is you do object, but you call it hidden hearsay. Objection, hidden hearsay, Your Honor. Okay? So those are the two examples of things that are hearsay, but only indirectly. The first is easy, personal knowledge objection, then you bring out the hearsay. The second is a little harder, but you can make a hidden hearsay objection. I'm going to skip over this next point. Okay. So an example of the beliefs based on hearsay is, and this happens all the time, right? When were you born? I was born on December 1st, 1982. Now, do you have personal knowledge of your birth date? And you say, of course I do. But think about it. Do you know what day you were born because when you came out of the womb, you looked up at the clock in the calendar? The giggles are for some of you who did, and that's why you've been so successful in your life, is you're incredibly brilliant. Some of you, however, may not have a personal recollection of that day you were born. I certainly don't. It was the drugs they gave my mother that fuzzed my memory, and that's why I don't remember. And if you push someone, they're going to say, well, my mom told me I was born, or my birth certificate says I was born. Hearsay. So the first statement is the objection, lack of personal knowledge, and the second statement is an objection based on hearsay. Okay, so that's the two-step process at work. And then an example, and I've already given this, so I'll race through it. The detective testifies, I arrived at the scene question A, and based on his answers, I went after B. If the actions are offered to prove that what A said was true, it's objectionable as what we call hidden hearsay. Okay, just a few more minutes of lecture, and then we'll take a break, and then when we come back, I'll get the panel together, and we'll go through our improvised hearsay quiz. So just one more slide, and then we'll take a break. And this is actually kind of an interesting situation. Machines and animals. It's very easy. The answer is machines and animals are not hearsay. 801 refers to persons. Okay? Now you want to be careful. There may be a person behind the machine, right? So you say, oh, I got an email from Jimmy. I printed it out on my computer. Well, my computer is not a person, so it's not hearsay. That tone is supposed to suggest a bad argument. That's not a good argument because ultimately the declarant is the person who wrote you the email, right? So don't get confused by that. But there are lots of cases where things are not hearsay because a machine tells you something. And as long as a person is not directly communicating through that machine, then you don't have a hearsay problem. And animals are never hearsay. Why is this screwy? Well, can you imagine problems of misperception, misremembering, and misinterpretation that you could ascribe to a machine or to an animal, right? Do dogs misperceive? Do dogs forget? Do you ever misinterpret what your dog is telling you? It happens all the time, right? I think my dog's just doing fine. I think he just wants to play. And he's really saying to me, I gotta go, right? 30 minutes later, I find out, the truth. So obviously, there are serious problems. But the theory behind this rule, again, is, right, what's the most important infirmity? Sincerity. Because dogs don't lie. Dogs don't lie. Now, you want to think about that for a second. Do dogs ever lie? Do dogs ever intend to deceive? Now, you might think that some animals lie because, some animals look like other animals. You say, well, I know insects that lie because they're insects that look like they're poisonous, but they're really not. But that's not intentional, right? That's because God made them that way when he created the world. So or evolution, if you want to think in those ways. That's not insincere. That's deceptive, right? But the deception is in the eye of the beholder. It's not the intent to deceive. Well, can a dog lie to you? Now, I was thinking about this because I was sitting in my chair, my comfy chair the other day, and Nigel, my dog, goes to the door and he barks, right? And you know what that means. It means he needs to go out. And so I got up to open the door to let him out, and as soon as I was out of the chair, he ran to my chair and jumped into the chair, right? So he was trying to trick me. He was lying. So dogs can lie. And you want to think about that. Well, can they really lie? Or does Nigel learn, and this is what people have thought about, does Nigel lie with the intent to deceive? Does he try to get me to believe something false, or does he simply know that if I bark at the door, he'll get out of the chair? Does he understand that what I'm doing when I get out of the chair is I'm thinking that he wants to go out? So the ability to manipulate behavior is something that animals have. But that ability to deceive strategically is something that animals have not been shown to have. And that's really what makes us different than animals. And that's what allows us to say that dogs never lie. So you say, well, we'll actually do this as one of the hearsay examples. And we'll see whether it's hearsay. So let's stop. It's 11:40. Come back at 11:50, and we'll do our panel and hearsay quiz. Oh, I guess that clock is fast. Our clock here says 11:37. So come back at about 10 minutes, but it should be about